My name is Alexandra Kleinfeld. I am the co-chair of the ADR practice section together with Ann Dalton. And I am a certified circuit civil, family and county mediator, also a qualified arbitrator. I'm very pleased that we have Henry Paul here today presenting for us. I'm sure he's well known, and I do have to say I could fill the whole hour just talking about Henry, because he has so many accomplishments, he has so much experience. He actually has been a member of the Florida Bar since 1985 and has served as a bar counsel in the Tampa branch of the Florida Bar for over 6 years, serving as liaison to grievance committees in Tampa, St. Petersburg, and Fort Myers. Henry has tried numerous bar cases and has presented oral arguments before the Florida Supreme Court. He also represents applicants for the Florida Board of Bar Examiners, and he has a history of representing plaintiffs and defendants involved in business disputes, including complex litigation. As a founder and former general counsel of the Tampa Bay Lightning, he has the benefit of hands-on business experience. Henry was appointed to serve on the Supreme Court Commission of Professionalism for a 4-year term, starting July 2012, and he remained an ex officio member until the commission was dissolved in 2019. Henry was appointed to serve on the Board of Governors Standing Committee on Professionalism for 3 years, and his term also started on July 1st, 2012. He was reappointed to another 3-year term in 2015. Henry was appointed to serve on the Student Education and Admission to the Bar Committee starting on June 1st, 2018. At the moment, Henry primarily represents lawyers in all matters before the Florida Bar and applicants before the Florida Board of Bar Examiners. He also represents lawyers in contempt proceedings. Henry is available to serve as an expert witness and to provide risk management services to lawyers. He's available for statewide representation, and he has offices in Tampa and Fort Myers. Henry is also an AV-rated Martindale-Hubbell, and he has a lot of experience and a wealth of information and knowledge in regard to any ethics. So we are very pleased that he's representing today on ethics in mediation and breach of mediation privilege, a 2024 update. So with having said all of that, again, I could continue, Henry. I really enjoy talking about you. So, but I'm turning over to you so that we can start the presentation. So thank you so much.
Well, thank you very much, Alexandra, for that very kind introduction. As we start this, welcome everybody. I don't think we have a lot of people attending, but I see Keith Grossman, who I got a very nice card in the email today from, Judge Weiss, and others. So I would I'd like to start out by saying I think many of us would like to be where Alexandra's picture is in the background after the last couple weeks. But I hope everyone came out basically okay. I think we're all suffering a little fatigue from what we've been going through, but fortunately, myself and my family have been safe. So I would like to start on the professionalism issue, because this outline deals with professionalism as well as ethics and mediation and an update. But I'll start with the professionalism aspect overall, because I think the most significant updates have been in that area. And I will focus on the updates in the new issues and the new items that have been developing and have developed. Just generally, I have attached my migration of lack of professionalism into discipline outline, updated in March. It needs to be updated again for some of the things I'm going to be discussing. Just to bring people up to speed, the standards of professionalism were first specifically identified in the INRI Code for Resolving Professionalism Complaints that was instituted in 2013 by the Supreme Court. and it identified the standards. There was a change in 2015 by replacing the ideals and goals of professionalism with the professionalism expectations. And the expectations are a much more mandatory, non-aspirational expression of what professionalism entails. And there's been a theme. I've been giving this talk for probably around 10 years, and it's been an ongoing theme, the migration. When I first started as bar counsel, we were trained that, generally speaking, unless there was something really egregious, that a lack of professionalism was not the basis for discipline, that professionalism was aspirational, as the ideals and goals clearly stated. But that has changed, and the expectations really exemplified that change. And as we go through and have gone through the time, these standards that are now identified with the Code for Resolving Professionalism Referrals in 2023 made numerous changes and revisions, but it still identified the oath of admission to the Florida Bar, the Florida Creed of Professionalism, the professionalism expectations, and the rules regulating the Florida Bar as the basis for the identification of these standards of professionalism. Another thing that the new Code for Resolving Professionalism Referrals did was the local professionalism panels were designated as confidential. And for those who may not be aware of what I call them the LPPs, local professionalism panels, this is an informal type of dispute resolution process, mentoring process that was initiated in the initial code in 2013, where someone can be referred to the local circuit professionalism panel basically because of uncivil, unprofessional behavior without having it stepped up to involving the Florida Bar. It's a very good dispute resolution process and mentoring process. And it really, people, and especially judges, I think, might consider using this instead of deciding whether or not they need or want to file a bar complaint, because although the LPP can look at the conduct and refer it to the bar, it's also a way of trying to educate members of the bar of how to comply with the standards of professionalism. And its intent is to be done in an informal process. And now that it's confidential, it bolsters the informality, and it also prohibits participants from trying to misuse the process and put it into the public, which is one of the reasons that the confidentiality was ordered by the Florida Supreme Court. The primary rule for enforcing violations of lack of professionalism is Rule 484D, which is conduct prejudicial to the administration of justice. Now, I'm not really going to talk about all the cases that I have cited in this outline, but I would like to talk about the updates and developments. First, I'll talk about is the Florida Bar's petition to the Florida Supreme Court to remove all references to a lawyer's duty to act zealously as a zealous advocate or with zeal on the client's behalf from the rules regulating the Florida Bar. The preamble to the rules of professional conduct currently provides that as an advocate, a lawyer zealously asserts the client's position, and the comment to Rule 4-1.3 diligence currently states a lawyer must act with commitment and dedication to the interest of the client and with zeal in advocacy upon a client's behalf. This amendment was sponsored by Reptile, the real estate property trust section of the Florida Bar. And they were concerned that they wanted to delete references to zeal and zealous in the preamble in Chapter 4. And they were, I'll just read what the order came down denying this amendment. It was August 29th, and I actually just saw it this morning in preparing for this presentation. And the court said in denying this amendment, they said, as to the amendments proposed to the preamble and Rule 4-1.3, the bar proposes deleting the terms because, quote, the contemporary plain language use of and reference to zeal are often associated with negative extremist behavior and character, end quote. And because the terms have been used by lawyers to justify unprofessional conduct, but the public meaning of the terms has changed little since we first adopted the preamble and Rule 4-1.3. And we have made it abundantly clear that zealous advocacy on behalf of a client is not an excuse for any type of misconduct under the rules, citing the Schwartz case, which said the requirement of providing zealous representation is not a sword to wield as an excuse to otherwise engage in misconduct. In citing the Norkin case, it said effective and zealous representation does not require antagonistic or acrimonious behavior, quoting the guidelines for professional conduct. So lawyers can still practice with zeal, but it really doesn't change the application of the standards of professionalism. The use of the term zealous representation has been around for centuries, and there was a comment in opposition to the rule that it would take away a fundamental proposition of lawyering. But the court, I really think it's a distinction without a difference, because the court's still going to apply very diligently the concerns and discipline over lack of professionalism. Another update that I'd like to discuss, and I didn't cite the Rule 3-71.18 in the outline, but I referenced the Florida Bar v. Reagan, which was a case that was based upon the pending Rule Amendment 3-7.18. And this amendment went into effect, I think, less than 2 years ago. And what it does is it allows what is called a judicial referral. And a judicial referral is a referral to the bar from a judge regarding certain conduct that a judge has concerns with. Once a judicial referral is made, it cannot be dismissed by the Florida Bar at ACAP. It cannot be dismissed by Bar Counsel at the branch. It cannot be dismissed by the Grievance Committee. It cannot be dismissed by the Board of Governors. It can only be closed with an order from the Supreme Court. So what this means is a judge refers a case. Case cannot be ended unless the Florida Supreme Court says it's ended. Now, there's all sorts of unintended consequences that may result from this rule, and I've been involved in several cases where there were issues of confidentiality. A lawyer has a right to respond and disclose confidential information to an appropriate and limited extent in order to defend themselves. Well, a judge, once there's a judicial referral made, is privy to all the communications with the respondent. So if the judge is still on a case, the lawyer's in a very difficult position of, well, do I disclose confidential information that may be harmful to my clients? It's going to go to the judge on the case. Of course, it may cause the judge to recuse himself, but there are going to be a lot of issues and unintended consequences that are going to have to be fleshed out in this area. But I've had several cases with judicial referrals, and the first thing I tell my client is, you have a problem. You are likely not going to get out of this case no matter what for a couple years, because the cases take a long time, and regardless of the recommendations, the Supreme Court is the only one who can dismiss it, and it's just, practically speaking, it's a long haul, and it's a very difficult case. I think in many respects it's been an overreaction to concerns that the Supreme Court had and the judicial councils had about the responsiveness of the Florida bar to referrals from judges in the past. There was great criticism from the judiciary about the bar taking their complaints and referrals to the bar with what the judiciary believed was adequate seriousness. And this is a reaction to that. Not sure if it's an overreaction, but it certainly is a big change than what occurred in the past. It is a dramatic change in the rules, and I think the most significant change in the rules in many years. And I especially caution litigators to be wary of this. I suggest that judges be very considerate and thoughtful when using this provision, because it does have very significant consequences. And what can happen, like it occurred in the Florida Bar v. Reagan, which all of the rule was pending, it was not adopted, but the bar acted under as if it were in effect. There was actually a finding of probable cause of Mr. Reagan because of the oddities of the procedural structure of the rule, where there was not a hearing before a grievance committee, before the Board of Governors, and all of a sudden there was a finding of probable cause. Mr. Reagan never had an opportunity to present his defenses, and I suggest that there's a real concern because it could happen again. There's a real concern with the due process afforded to a respondent who is put in that situation where notice and an opportunity to respond to the notice of the charges should be afforded to a respondent. Well, in certain circumstances, that is not allowed under this rule. And that basic due process rule is a 1968 Supreme Court case, U.S. v. Ruffalo, which is the basic standard for due process and disciplinary proceedings. So there's a lot that's going to, of litigation that I predict will result from this rule and the application of this rule. The next development that I'd like to talk about deals with the disparagement of a client. And the case that I've cited here is the Florida Bar v. Knowles. I did 3 consecutive res gestae articles on this issue, and it deals with not just disparaging a client, but how to respond to a bar complaint. And the Supreme Court, and there are many other cases, but I thought that these 3 were significant in enhancing the discipline of a lawyer for the way they responded to a bar complaint, being dishonest, disparaging a lawyer, and it can significantly enhance the discipline. The cases were Greco, Mirabal, and Catalinic, and I will discuss the Catalinic case here. And again, it was a recent Res Geste article. But it appears that the bar complaint against the lawyer was really meritless. And instead of responding with a reasonable response explaining why it was meritless, I mean, no one likes to get a bar complaint. No one likes to get a bar complaint and spend the time that it takes to respond to something that is really a meritless complaint. But it needs to be done, and it needs to be done professionally and appropriately. But instead of responding in a reasonable manner to what was a meritless complaint, Mr. Catalinic wrote to his client, "Please do not threaten me or my office with physical harm. Unfortunately, I had no chance but to make these emails that Catalinic had sent to him threatening a bar complaint, which he shouldn't have done either, about the conduct. But he said he had no choice but to make the part of your emails, the emails part of your aggravated stalking court file, which was the basis of the representation, an aggravated stalking case. He filed these emails in the court file. There was, and then there was no justification to file the allegedly threatening emails from the client in the court file except to attempt to disparage the client and make them public. Mr. Catalinic also sent the client's emails to opposing counsel and the opposing party. Mr. Catalinic also falsely responded to the Florida bar that his client had been fired from employment at the sheriff's office. He also falsely stated that his client had fired 2 previous lawyers and attacked them with harassing emails, phone calls, and negative online reviews. When the grievance committee investigated, they found that these allegations were untruthful. And the court, stated it enhanced the discipline for breaching confidentiality and disclosing things that shouldn't be disclosed. That was the Knowles case. She disclosed, Ms. Knowles disclosed all sorts of disparaging information to different parties, law enforcement and otherwise, causing harm to her client. And she got a lengthy suspension for that conduct. But I see in my practice a lot of lawyers who just want to have a scorched earth policy. You have to keep in mind that there's still an obligation of confidentiality. You can disclose information, but not only that, it's reasonable and necessary to disclose. You just can't go out on a free-for-all to disclose confidential information responding to a bar complaint. I recently was involved in a bar complaint in which a lawyer responding to a bar complaint in a very serious criminal case disclosed extremely incriminating information. Now, I got involved, a lawyer got me involved to try and protect his client's rights. And it turned out that the matter was sealed as I requested. I don't know if that lawyer who disclosed that information is or has been or will be disciplined, but it was certainly a serious breach of confidentiality. So I just caution those in responding to a bar complaint. It's not free license to disparage the client. Unfortunately, it happens too often. In the recent cases that I cited, shows that the court does look at that and does discipline lawyers for going too far. Another update that I would like to note is the Board of Governors standing policy that was recently amended. And I will read what it says. Standing board policies are just general procedures that the Board of Governors operate under. And it's not just related to discipline, it's all sorts of operating procedures on all different functions fulfilled by the Florida Bar. But this one is in the disciplinary section, 1556E, and these are available on the Florida Bar website, I think under the Board of Governors section. The amendment states, absent unusual circumstances, Bar Counsel should not agree to extend deadlines for more than 10 days and should not grant a request for extension without a reasonable factual basis for the request and should not grant more than one extension. Well, in the past, the Florida Bar has been very reasonable, liberal with requests for extension. And this is a change of policy. And it's also included, that exact language or the citation to that amendment is now included in all what they call 15-day letters. So letters sent to lawyers providing them with the bar complaint and 15 days to respond. That is included now in the text of the letter. Well, I can tell you that there are many good reasons for extensions to be offered, including one of the most common, that materials need to be obtained. Transcripts sometimes need to be ordered. Sometimes they're very complex matters in cases. And to impose a policy of one extension of 10 days can really cause a problem to the bar. It can cause a hardship to a respondent, and it can burden the disciplinary system because of time-stressed responses are not adequate and not thorough enough. I also, and I did write a Res Geste article about that, I also think it's very contrary to the position that the Florida Bar has been trumpeting regarding professionalism. And if you look at professionalism expectation 6.4, it requires a lawyer to accede to reasonable requests for extensions. Well, I can only hope and I expect that Bar Counsel will keep that in mind. You know, it's often said you can't let a client dictate whether you can act in a professional manner. Well, the Florida Bar, I would suggest, also needs to be bound by that. And so far, I have not run up against what I consider to be an unprofessional response by the bar when needs have dictated or required a request for extension, including for the hurricane. But I can tell you it's a lot more limited than it used to be. And I'm concerned about it. And lawyers need to be concerned about it when they get that letter in the mail. And by the way, even though the rules direct the bar to use electronic communications as much as possible, the bar still sends initial bar complaints by the mail, doesn't give it any additional time for mailing. It's just a little pet peeve I have when I get the bar complaint and there's a time issue in responding. You know, the initial response is a very important document, and I often talk in CLE presentations and with my clients. It governs what happens with the rest of the case. It's a roadmap that it's significant all the way through the case if it goes to trial or is disposed of otherwise. And time needs to be spent to respond adequately. So I caution lawyers, when that bar complaint comes in, no matter what you're doing, look at it and deal with it and take it seriously and spend the time to respond to it in a very serious and thorough manner. This just adds more stress, this amendment, but I can tell you it does make it more difficult. Okay, I think that's the update on the professionalism issues. I will just point out there was another case, the Lee case and the Farrow case, which I think I'd written an article on, where the respondent had claimed that that professionalism was aspirational and defended allegations against them for discipline by making an argument that the First Amendment protected it against discipline based on lack of professionalism. Well, these lawyers didn't get disciplined that seriously, but the referee, again, repeated what is common knowledge in the disciplinary practice area. First Amendment is not a defense to lack of professionalism and lack of communications that are and communications that are unprofessional. I also wanted to make a comment on the standards and goals of professionalism. All those standards are now routinely cited by the bar and the court in imposing discipline. In addition, in the case I was just talking about, the Lee and the Farrow case, one of the allegations, the basis for discipline was the bounds of advocacy, which was a document propounded by the family law section of the Florida Bar, and it was incorporated into a local court's rules, instructing that its lawyers, or an order, like an administrative order, saying, well, lawyers shall be bound by the bounds of advocacy. And that's one of the reasons that the respondent was questioning, well, that can't be the basis of discipline. And basically it can. And other local rules in many other cases are being incorporated to support discipline for violation of those local rules. So it's very expansive. And what was once aspirational when I started as a member of the Florida Bar, as a bar counsel, has completely changed. And you look at it every week, every Thursday at 10 o'clock, Supreme Court releases, dispositions and filings that have been made in disciplinary cases. And you look at those cases, and lack of professionalism is very commonly a basis for discipline now. Okay, let me turn specifically to mediation. Excuse me. And I just go through my outline generally as noted in Rule 10.350, a mediator shall be patient, dignified, and courteous during the mediation process. And that applies to participants in the process as well. And I quoted the excellent Florida Bar Journal article, Good Faith Mediation Orders, which was a 2015 article talking about, the parties are also bound, at least the lawyers are bound by the rules of professional conduct and the standards in their participation. And I cited some MEAC opinions here in relation to reporting unprofessional conduct or other conduct in violation of the rules that highlights the obligation of the participants to act with within the professional standards. I hear a lot of complaints from mediators and participants in mediation of unprofessional conduct. And It's unfortunate. I think in some respects, I think there's a feeling that by some participants that they can get away with it, that the rules don't really apply in mediation. But with what is going on in the world of the disciplinary process and the enforcement of discipline for lack of professionalism, I think it will spread in the future, if it's not already growing, willingness of mediators to report lack of professionalism to the bar or even to a local professionalism panel. I'd just like to briefly discuss these MEAC opinions. Of course, confidentiality exceptions are found in Florida Statute 44.405, 4A, and 4A deals with malpractice, 4A6 deals with professional misconduct, 4A2 deals with crime exceptions, and in MEAC 2011-03, the MEAC opinions, there was a very unprofessional lawyer involved, and they said that they may report a lawyer to the Florida bar, but of significance in this rule, it discussed fairly extensively the application of Rule 483A, the obligation to report. And I think that the discussion is basically indicating that, you know, a mediator may even have an obligation to report unprofessional conduct. I think that their discussion of 483A is a bit overdone, because 483A says a lawyer who knows another lawyer has committed a violation of rules of professional conduct that raises a substantial question as to that lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects must inform the appropriate professional authority. Well, as far as I know, there's only been 1 or 2 cases nationwide where a lawyer has been reported for not reporting a lawyer for misconduct or violation of the rules. And I think that the MEAC opinion overstates the obligation of a lawyer to report. And it's sort of at odds with some subsequent MEAC opinions, which clearly state that a lawyer may report but is not required to. Just note that this unprofessional conduct was under 405, 4A6 involving an exception for violation of the rules, basically. And MEAC 2012-02, there was a disbarred attorney, and the mediator asked if they could report, should report, and the opinion said may report, and sort of receded without mentioning the previous MEAC opinion. And it was based on A2. UPL is criminal conduct. And in 2023, opinion 2, there was a mediation that was videotaped by a participant without consent or knowledge. Again, an 4A2 criminal type violation. And again, the opinion said may be reported. I'd like to caution mediators or others in reporting to the bar or other appropriate authorities pursuant to an exception that the rule says, at least under 4A6, to be used only by the the authority for the purposes of the investigation and discipline. I routinely, when I'm involved in a bar case, cite that rule and ask that the matter be sealed and kept confidential, because once a matter is disposed of past the staff level or the grievance committee level, they become public records. So very commonly you'll see a complainant who is in a mediation complaining of a lawyer's conduct in the mediation. When I get involved defending that case, I ask the bar and cite the rule of judicial administration, and specifically cite to that section of the rule that the matters be sealed. The bar does not respond very with a great deal of attention to that request. I make it regularly, and I think it should be made regularly. A lawyer can defend himself and get into mediation issues, but in doing so, I strongly suggest making a request for the bar to seal. And I outlined the appropriate sections and rules in the outline. Also, if you're concerned about something, it's also a good idea to ask the bar for permission to disclose something, and also request that it be sealed upon disclosure. I did also want to talk about where there were some breaches of the mediation privilege, and there were not exceptions, like the exceptions we talked about up until now. Just now, the Florida Bar v. Perry, a lawyer was disciplined 60 days for breaching the mediation privilege. Now, there were other issues involved, but it shows that discipline can be imposed by the Florida Bar, the Supreme Court, for breaching the mediation privilege, for attaching to a pleading something that was confidential pursuant to the mediation. There is clearly a precedent for discipline based on that. Also, you had the Mintz-Trutman, the Cozen O'Connor case, in which one law firm sued another law firm. There was a first-party insurance case in federal court, and in response to a request for attorney's fees, the defending law firm defending the attorney's fees disclosed information about the settlement offer in the mediation that was made in the mediation to try and reduce the attorney's fees, because the results obtained was an issue in what fees were awarded. They tried to undermine the position taken by the law firm seeking fees by discrediting the success by quoting what was done in the mediation. Instead of raising the issue in federal court, the law firm filed a suit in state court citing 44406, the damages and remedies for breach of the mediation privilege. And in a peculiar procedural process, the court said that granted a writ of prohibition, said that they could sue. It went up to the Supreme Court where a writ of prohibition was granted. They reversed. And anyhow, what happened with prohibition really isn't of interest, but what is of interest is that there was a lawsuit brought based on breach of the privilege. And there's other cases where there have been sanctions. I cite the Peranzino cases, the Geico case, which I did not cite. Case was reversed for breach of the mediation privilege. I suspect in the future, with the example of the Trutman case, there may be other cases brought for breach of the mediation privilege based on 406. I'd like to talk about one case, the MEAC 2024-001. Thought an interesting case where a mediator was contacted post-mediation and was one of the parties and his client, his lawyer, her lawyer, approached the mediator, and the wife, the client, apparently was maybe having second thoughts about how good the settlement was for her. And they contacted the mediator and wanted to talk, I guess had the mediator tell the client that it really was a good settlement. And I thought it was unusual, but the MEAC opinion was interesting to the effect that it said it can be okay for a mediator to have contact with one of the parties post mediation, provided that no confidential information is disclosed. There was no rule prohibiting the mediator from reiterating the negotiations in the case. I found particular interest in that case because I was involved as an expert witness in a case recently where there was an attempt to rescind a settlement that had been mediated. And I was very surprised to see that an affidavit from the mediator in support of the party who was seeking to enforce the settlement was given. And I presume it was under Rule 4A5, which is an exception to confidentiality regarding enforcement or revision of settlements. Not seen that before. I was quite surprised to see the affidavit by the mediator, but I just point out that that did occur. I'd like to give an update briefly of 3 mediator qualification disciplinary review board cases. In case 24007, a mediator failed to disclose a suspension from the Florida bar to the board, and he was suspended and could not be considered for reinstatement until he was reinstated by the Florida bar. So if you're a mediator who gets suspended or disciplined by the Florida bar, it needs to be reported. In case 2023-14, there was some sanction, I think basically just additional continuing mediator courses for failing to implement and obtain a written fee agreement for all the participants in advance of the mediation. And then in 2023-007, and these reports aren't very detailed, but apparently the mediator was sanctioned for simultaneously acting as the plaintiff's attorney in a case in ongoing litigation against the defendant insurance carrier and acting as a mediator in an unrelated case in which the defendant insurance carrier was also the defendant. So I guess acting as a mediator for someone who's for a client, insurance company that was represented in another case. I don't know from what's disclosed here, what disclosure, if any, was made, but it's certainly an obvious problem regarding conflict of interest. So that is my update. Kind of rushed through it. If anybody has any questions, I think we're about out of time.
As always, Henry, a wonderful presentation. Thank you so much for the update. I do have a question.
Sure.
So during mediation, you are the mediator, and you are under the impression that one of the parties who's represented by an attorney, that basically the attorney is making all the decisions. And you can see from body language, facial expression, that the client is not really okay with what the attorney is saying. So it's a difficult situation. I mean, we normally have to hear from the client, and I know a lot of attorneys will talk instead of their clients and represent the case and what's supposed to happen. But if you really have the feeling, it's like, okay, that's not really what the client wants, that's what the attorney wants. You are basically in a dilemma, because how do you deal with, okay, you can ask the attorney, okay, I need to hear it from your client. And when you see the client like, yeah, I don't know, I think so. That's a situation where you're like, okay, so it's not really clear to me that it's self-determination from that client, and how to come to an agreement, if at all. How would you handle that?
I think it's obviously, you wouldn't ask it otherwise, a very difficult issue. I think it's a good question for MEAC.
Right.
I don't have an easy answer for you. Maybe
Right.
somebody else has some experience or thoughts about that, but I think it probably runs the risk of overreaching. I don't know. Does anybody have any practical tips or situations that they can give some advice on that type of situation?
I mean, I know you don't want to undermine the attorney who is
Right.
representing the client, and the only, I mean, thing you could probably do is take the attorney out of the room, talk to the attorney maybe for a minute and say, hey, listen, I really need to hear this from your client. I have a feeling that it's not really what the client wants, but then the attorney will be mad at you as the mediator. And as you said, overreaching, overstepping. So it's for me, it's like a situation the mediator cannot really win.
I think your suggestion seems like a good suggestion. I think that's a great MEAC question. Well, getting some guidance on that. What do you do?
Right. Because you still, again, the client has to be self-determined. And if you think, okay, it's not the client that's making the decision, you can only say, okay, I'm sorry, I have to terminate at this point, and basically don't give an opinion or reasoning why you are terminating.
So I wish I had a clear answer for you. I don't.
I appreciate it.
If you read the mediation rules and the MEAC opinions, quite honestly, the concern about whether the lawyer is going to be upset with you really isn't taken into account in the rules and the MEAC opinions. That's a practical situation, but you have to, as the mediator, make sure that the clients are exercising self-determination. It's one of the most paramount aspects of mediation. And so making sure that the client understands. And in addition to what you said, I might ask the attorney some questions in front of the client to make sure the client understands what they're obligating themselves to, and that once they sign it, they can't change their mind.
Excellent suggestion, Keith.
Yes, thank you. Okay. Does anybody else have any questions? You have the chance now, because I know Henry is a well of information, and if I have anything I would like to discuss with Henry, he always has an open ear. So I appreciate that very much, Henry.
That goes for everybody.
Yes, so thank you so much. So if no one has any other questions, again, thank you. Always a pleasure to have you, Henry, and update us on ethics, professionalism, to make sure that we do what we need to do. And I would like to point out our next CLE that will be on November 14. And we actually were able to get Carla Campos Anderson, get us a little bit of cultural diversity CME points. So that is great. She is acknowledging cultural diversity in mediation and how different cultural backgrounds can affect the way people negotiate and resolve disputes. So please tune in November 14, same time, 12 o'clock to 1 o'clock, and it's via Zoom. So having said all of that, thank you everyone for coming. I hope you're all okay after last week, and continue to be safe until we see us again next month. Thank you so much.
Thank you. Goodbye.
Bye, everyone.
Thank you.
And the CLE will be emailed.